My never I say ma PENDREAM TV. PENDREAM TV there. I see them yopo.
Yo, ene de omanpenyine Akuffo Addo na dapa ene daso yi ne to adadi papa wa kire se onye omanpenyine a oka no kure na honorable Mahama Ayariga ekotna TV3 so na ne nsem bi a oka in fact me kan se expose efa LGBTQ nturumun sensam no a omanpenyini Akuffo Addo bedi ntro eka kire Ghana for se obi di asam no court enti enu nti no oman executive secretary etro letter e de call the clerk of parliament say ma yemfale ayi anti LGBTQ plus what do you call it bill na embre no kra sa na ade no enye sa na tie so mun nyam dim say honorable Mahama Ayariga oye obi a oye lawyer ankasa na ura asem no mu a sa omanpenyina Akuffo Addo omodi sete wa no omodi aye omada Charlie serious na mepesi yeko na yekohwe sede esiye ne sede osika ne nsam no esifa ye wia ne aba abeto aye nkomo no so mesro ansa na yebeko no mesro so be subscribe to PENDREAM TV ba ya no wa subscribe to channel no na wa boayen no wa like video no my who like ya eboa ma video no ekwa akire ma afoforo so enya information we bi ehwe and wo like pe eboa ma video no kwa akire enti o adwenkyere bi susu a na wo de ato comment section na se no wa share ma afoforo so anya bi atumi ahwe yenko hwe honorable Mahama Ayariga wo bra na o take key point e wo TV3 so ne wo bra na o di ne nsam tudwa efa LGBTQ and bill na o manpenyin se ontimi nsan yenko hwe mra sisia.
Thank you. Can I get to yes. Arrogance. I disagree. Hold on. Let's all have one person speaking. It's fine. Let's all have one person. Thank you. Can I let's have some discipline.
Can I have? Yes. But they are talking.
I wouldn't do any law. For example, yes. Thank you.
There are two issues There are two issues. Excuse me. There are two issues that I want us to have clarity on. One, the application to the court and the reliefs sought by Richard Sky are captured here, and there are two. An order of interlocutory injunction to restrain the Speaker and the Clerk to Parliament of Ghana from presenting to the President for his assent through the Attorney General from assenting to the Human Sexual Rights and Family Values Bill passed by the Parliament of Ghana on 28th February 2024, pending the final determination of the suit. So he's seeking to restrain Parliament from presenting the bill. Yes. But that's a relief aimed at the Speaker, not the President. Okay? Then the second one is to the President. An order directed at the President from giving his assent to the Human Sexual Rights and Family Values Bill 2024, passed by the Parliament of Ghana. So he's seeking to restrain Parliament from presenting the bill to the President. Then he is seeking to restrain the President from assenting to the bill. He has not sought any order to restrain the President from receiving the bill. He has not.
Oh, but you just read
No. That order is aimed at the Speaker. Read it carefully. It says, an order of interlocutory injunction to restrain the Speaker. And the Clerk of Parliament from presenting to the President. If they choose to go ahead and present it to the President, that becomes their legal problem. The President is not restrained by the reliefs being sought by Richard Sky from receiving. Do you get it? Now, the secretary to the president, writes his cease and desist letter. And he says this, and let's read it carefully. He says that the Attorney General has, by letter dated 18th March 2024, informed the president that he has been duly served with both applications and has advised the president not to take any steps in relation to the bill until the matters raised by the suits are determined by the Supreme Court. It is the understanding of this office that both applications have been duly served on Parliament. Therefore, it would be improper for you to transmit the bill to the president, and equally improper for this office to receive the bill. That's where he's wrong. It may be improper for the Parliament, pending the issues of the application, to transmit it, but that's a matter for them to decide whether they want to be in contempt. But it is not improper for the president to receive it, because nobody has sought an order to restrain him from receiving it. The only order that has been sought is to restrain him from giving his assent. But because, in my opinion, my candid opinion, the whole writ was contrived to give the president a cover not to receive it, even though there's no order in relation to him not receiving it, he just jumped at the writ and said, hey, I don't want to receive it because there's a matter in the court. So clearly, it is wrong. But that is even not for me the only issue. There is an even more, listen, there is an even more fundamental issue. Let me finish.
Gentlemen,
please.
Thank you.
There's an even more fundamental issue here, which has not, in my opinion, in all the discussions that I've heard, been canvassed. Therefore, let me continue the quotation. Therefore, it will be improper for you to transmit the bill to the president, and equally improper for this office to receive the bill until the Supreme Court determines the matters raised in the suits. Indeed, it is settled law that during the pendency of an interlocutory injunction application, the status quo ante ought to be preserved, and no action should be taken that will result in prejudicing the injunctive relief sought and determining the authority and undermining the authority of the court. In the circumstances, you are kindly requested to cease and desist from transmitting the bill to the president until the matters before the Supreme Court are resolved. This is equally palpably wrong. Do you know why? The same Supreme Court, in the interlocutory application by Amanda Odoi, Amanda Odoi, in her interlocutory application to the court said this, and pay attention. The court said, we have considered the merits of this application before us. It is our considered opinion that a prima facie case has not been made to convince us to restrain the work, listen carefully, to restrain the work of Parliament in its uncompleted form. To restrain the work of Parliament in its uncompleted form. Uncompleted form of what? The passage of legislation. So the Attorney General ought to have advised himself as to what is the completed form of legislation. The completed form of legislation is when it is initiated in Parliament, goes through first, second, third reading, after consideration, gets voted by parliamentarians, is transmitted to the president considers it, either assents to it or refuses to assent to it, sends it to Council of State for advice, takes the advice of the Council of State and the opinion of the President and his recommendation, sends it back to Parliament. Parliament considers or reconsiders its provisions in addition to the views of the President and the Council of State, and either passes it by 2/3 majority or not. That is the completed form of the passage of legislation. So the Supreme Court has already indicated that in the entire process of the passage of legislation, we will not interfere. So it is wrong for the Attorney General to have been said to have advised the President that he should not assent to the bill. When the court has already said that, we don't want to even interfere. So even if somebody has brought an application to us, we don't want to interfere, go ahead, go through the entire process. So the entire process includes the President saying that I disagree with you, I'm sending it back to you, go through reconsideration, mobilize your 2/3. If you succeed in passing it, you bring it, and I assent. That is the entire form. And the Supreme Court has already pronounced on that matter. So it is wrong for the Attorney General to ever advise the President that he should not go through the processes. One, either say, I disagree with you and send it back, or two, say, I'm signing, because when he signed, it is still part of the process. So he hasn't violated any rule. He hasn't undermined the judiciary. He hasn't violated the decision in Amanda Odei. And in fact, he has complied with it when he goes ahead to either assent or refuse and communicate it back. So the Attorney General was wrong. In fact, I am shocked and scandalized by the advice of the Attorney General in this instance. That's what I want to highlight this morning in this discussion. So I disagree with what has happened. The second issue that I think we need to understand is that I have an issue with the Supreme Court ruling in this interlocutory application of the Fiamako. I may have some reservations about the righteousness or not of the letter that has been written, okay? But what is the substance of the Fiamako's case? The Fiamako is relying on Article 81 of the Constitution. What does 81 say? It says that the office of a Minister of State or a Deputy Minister of State shall become vacant if his appointment is revoked by the President. The President writes to Parliament, lists people and says, I have revoked these people's appointments. First,
can I caution you?
First,
you are almost determining the matter.
No, we can discuss it. No, we can discuss it. No, we can discuss it. Nothing stops us from discussing the
matter. Let me even state that we are mindful of the subjudicate, and so we are mindful of our timelines and then also the boundaries in the conversation of this case. So yes, we are not really determining the case on this platform, but we are discussing it within the boundaries that we are allowed to.
We can discuss the facts.
Yes,
the facts are public record.
Yes, indeed.
The communication was read to me.
Yes, that's that. I just needed to state that.
The communication first said that these appointments have been revoked. Then after saying these appointments have been revoked, then below, so I have reassigned them to X, Y, Z. Then the Fiamako said, but you've already revoked the appointments. So if you have revoked the appointments under Article 81, where are they to be reassigned? This is the case.
Go through the process.
Yes, this is the case before the Supreme Court. Now the Supreme Court says that, don't worry, you go ahead and do whatever you have to. I won't grant an application for interim injunction. That is so. I don't think that we should relate the substance and nature of the Fiamako's case in relation to Richard Sky's case. Because in Richard Sky's case, so far as I'm concerned, in the Amanda Odei rejection of interlocutory application, the court has already ruled that whoever is a participant in the entire process of the lawmaking should continue with their responsibilities and not be restrained, including the President. So for the Attorney General to advise him against giving his assent and not advise him to take the steps dictated in the form is woefully wrong, and I feel scandalized by it. Then on this, you see, I take a position personally that there's no specific rule that says that when you write to the Chief Justice,
notify
to seek an early hearing of a matter, that you must necessarily copy. But I have said here that it is only proper for you to copy
on the platform of fairness.
Yes, on the platform of fairness and also just administrative prudence. I also agree that when the Chief Justice is responding to you, because there's a third party involved, is that okay? That the Chief Justice notifies the third party, copies the third party, so the third party is aware. I heard somebody said, and I think I 100% agree with that administrative.
That's what Biban said.
Yes, his position, and I think that was administratively, not the best that the Chief Justice did not copy, the other party when responding to the lawyers applying for an early hearing. But, the reason why the Chief Justice ought to inform the other party is that if you read the notice to, let's say, the former court lawyers, what does it say? It says that, let me read it. That is fixing of date for hearing of application generally. It says, please take notice that a date will be fixed for hearing of the above stated application with hearing notices for the respondents by the registrar upon request 14 days after service of the application on the respondent. 14 days.
14 days.
So when you send an applicant this notice, that applicant legitimately will expect that he has 14 days. Okay? After the service on the respondent. So there is a legitimate expectation that I have this time frame within which to work. If you then decide to go ahead and then have the hearing much earlier, I think that administrative prudence will require that they be given adequate notice. And I heard the lawyers indicate that they have issues with the service, and they actually indicate that the bailiff lied to the court. Bailiff lied to the court. So I believe that in a matter like this, given the political nature of this case, the Chief Justice should cause an investigation of the conduct of the bailiff.
At least on the face of the CCTV video we have just shown.
So that we are all clear as to exactly what happened. Because like Prof has said, this is a matter that deals with the reputation of the judiciary. Already, NDC has issued a statement questioning why this matter came before this other matter, and yet you are choosing to hear the one that came, after the first one. So it is important for the image of the judiciary for them to be interested in whether or not, because I heard the lawyers on radio say that the bailiff lied and that they have CCTV cameras. And they've shared the CCTV cameras. You've shown it. I watched it. You've shown it. So, in the light of this, I believe that the Judicial Secretary and the Chief Justice should be interested in investigating the conduct of the bailiff to see whether he misled them into refusing to give an opportunity to the applicants to be heard. Because it's a rule of natural justice that the party should be heard. And that is why I decided to go to the substance of the Kwemofos case. Because I believe that if they had heard him, they would have seen that first, Parliament is on recess anyway. Are you getting the situation? And secondly, really, he's not really talking about the process in Parliament, essentially. He's talking about the conduct of the president, even before coming to Parliament. First announcing revocation, and then purporting to announce reassignment. So it's not the same thing. It's not a process in Parliament. Okay? It's the conduct of the president outside Parliament. So I think that there's something to distinguish in relation to the two matters that are before the Supreme Court. And even though it is all in the context of a political tussle between the legislature and the executive, but in truth also, there is a legal issue when it comes to the Kwemofos court case. And there has never been a precedent like that. And we're all interested in what the Supreme Court will say in that matter.
Let's see how things play out. And you talk about the tussle between the judiciary and the legislature and the executive.
I said I wanted to make a 1 minute submission before.
Yes, let me acknowledge that.
Kakum, esi ejino kokuanu wa hwe de papa yi ekanya onabo ekanya na che se omanpenyini oni ye andi ni yi wan omanpenyini Akuffo Addo oni ye andi ni yi kra na botaye panti la omampanyini eye saa de wi so no say a shock me like me dwene ho a mente ase say enti oman a sebe ye nyina ye nimu say ye values ye norms ye culture any saa de wi eye ebabra say eye ye chiwade na wo omampanyini wo manfo ato aba ma akotena so se hwe oman no so bedi nyina yanim na asam aba na wo manfo ni nyina adwena bom Ghana nyina obi antumi nyine hu mfrim because 275 what do you call it parliamentarians no, none of them baako kropo ni ho a oyi ni hu mfrim so ono one bill no enya adwene omu nyina ko to kro ena omo pass ye enti no obi antumi nyine hu mfrim e Ghana because omo ye ya nansifo ena omo koye enti se omampanyini wo Akuffo Addo ya ye de wa besi ano se bedi enkan na se Ghana nyina ye sei ni ye pe na wo se wo no onye na se de ye pe no be ye na se de wo pe ni wo interest then na eya sefesem na eya odwene ho a wonte ase se adenti ena wo so omampanyini Akuffo Addo etu saa anamon no edie na omampanyini Akuffo Addo ehwehwe edie ba ketua no ohwehwe afiri abrofo yi nchen a enti no oton oman Ghana oman kronkron Ghana shebre oton ye shebre edi akoma sa nkrofo yi se yen sei no edie mpa ena omampanyini Akuffo Addo peso sabio omaye dane mmoa odane ye mmoa edi masa nkrofo yi sabi ye Ghana ana Africa ye ti akrampo ye problems ye intimi solving we Africa ye problems ko ye intimi solving we are underdeveloped na omanya etisei o se yen sandane ye ho mmoa ni yen start say afi de oba ne berema o sabi oba ne oba enkoda na berema ne berema enkoda ne ema ho kwan masabio abranti a ne ho sisi ne ho so se enko ware aponche anakraman na praku se ne yere na one praku da na oba so nsori enko sabi enko fa ebia ponko anase odwan kraman say me so kraman we na me fi say me ware no enti me pese me ne kraman no ekoye wed ne betena fi so oyire ni okunu na oma kraman sabi ene ne da sa sabi emu asemi efiri himfa anti omampanyini Akuffo Addo oji atum say o de o pese yeye all because of sikam no kofio wa funti sabi enti sika wa die o Ghana ho mawia wo Ghana ho ensomo de mu fi se ebitimi aboa mo biem pa ne se mo beton ye hyebre Ghana hyebre the generation yet unborn omo hyebre o ton e de ama abundance so for so omo mbe like omo how why must you betray your country like this wo bra woni say wan kasa o constitution na nkasa na etia sa ade no ade na yesawo Supreme Court ankamu judiciary ankamu di munan besi from ama omampanyini Akuffo Addo no ahunu say look oman no ye wo mra ye hyemrase ye di mra so enti no say parliamentarians ateki sa position we are wo president it binds you to also so no you have to follow the procedure sempo o adwenkyere bi wo ho ananti ase bi wo ho a unim kwan ye wo sa wo fa so na wo tu ho anamo na wa unim say eye injunction no krampo na the last guy at the court no baby eni wa ya twero say ma ye mfa ade na mrew de waka na say ma parliament emfa mrew ena wo so man sign eno ano no nti letter wo ma wo executive secretary twero ba ye say prevent parliament from bringing the thing to you no na se kire ne say is it that Won wakoshe the last guy echi. Ena wo propagate ma emaniko look like say pese wo de ubum raso na mum sumase no wo na wo sha ase ena mo chese kuntuna ase ena mo pese obi hye daye sa ase ne be prevent wo omampanyini Akuffo Addo from signing enne wa magana fo nyina ene asofo imams wo krum ha enyina hunu se wo ena wo pese saa Trumutu yi saa Trumutu wo na wo pese ogitum woni wa Bediatuo mate Baumia because up till now Baumia ntumi mbie na no nka saa asem ho bia ontumi nka bida. Up to now, a major issue like this, a national issue like this. Now, Dr. Mahmoud Baumia ntumi mbie na no enka bidia na ene de na kana say we de Baumia onka no kre. Onka no kre. I was say Ghana media near one day the pressure to so me tie wo so anu asem ye wo say the pressure said the more the pressure share that top omampini Mahama so say on kabino already Mahama bra no e president o ka ho asem e reject ye bra no e vice president ne boss Professor Atamos o ka ho asem e reject ye unso obey opposition leader yi wasa pushi na manasa be can the same thing. Now wo na one wo contest a wo abai mu no wo dodge wo serve more preventing people from even asking him such a that question. Dia mpa na ekoso enti Mamudu Baumia e person o kire se ono ne kristo ne nkran musoma a wosom no enti ogitum o tiase o like wagiatum se emno ene yemfa o nya adwuma okrum ha na dia na ekoso Ghana for mama mani enna ho na ese Ghana no obi ahu se omampanyina Akuffo Addo ena epese saa nturumu ade no ono na apenso ena eye adwuma e wo Ghana ha because ono waka aka sisu dua e wo Al Jazeera obro call interview so it is bound to happen if offensive pressure is being mounted on the county eto ono no oto ho no by now crampon call or expectation can crofo be sorry na nkoma he na chese enka na ebesi no na nkasi na chese wama ade no aye adwuma anse mi motie say yes sa na busua mu de Trumutu no de chese it say by final form. Is that the reason why the president is not able to assent to it? Enunti eno mampanyina Akuffo Addo ntimi san na die na ekoso se saa asem no ye no kra enunti na mampanyini untimi san na se be se ye no kra mpa enti oman no eye wo no wabusuafo dia so oman ni nyina se ye penisei enko nifa wo ne hwan na waka se wo ne omanti ni wabusuafo nti o ma de ne nko no it is wrong obeswe emma oman no ekire oman no wa meso ama wabusuafo oti ase obeswe e de ma oman ekire oman no wa meswe ankire wabusuafo enti aba na san ena se wabusuafo sabe omo na ye gay ni nturumu ni lesbianism ni sa anyoma na obeka so omunti if sanity obeka so omunti wo no wonya den on ascended to Adia Ghana Parliament backed by law na oma shemra akuchi edi abra wo say media mamon fam mame office mpo. What is that? Ana for mayani na ho momma yani enna ho na oman chechire say ya na tie so wa mo wanu ene wo soso modemo amba mu bia say ya it will go and come back to affect your generation yet unborn. Umama babe affect you mo obi wo ho no anya kape na me de me mfa ho mbe bia omo anka so masam me mfa ho o mfa ho ada ne adoyi e na osi soro ho e na wo de wachira asam okay one day it will get to your doorstep ho na obi hunu se ye ton dokono a ye gishito aha PENDREAM TV. Make sure also be subscribe to the channel. O subscribe we are na wa like video no. O like we are no wa adwenchire bia na we to comment section no ase na wa share video no so ama foforo so atumi anya bi ahwe PENDREAM TV yese edamu yopo.
My never say PENDREAM TV. PENDREAM TV there, o say dem yopo.